Greetings. Welcome to Talk Law with Monare. My name is Monare and I'm your host. This is the third episode in our labor law series. So today we're discussing payments which are due on termination of employment. And the first point to mention is that employment may be terminated by either the employer or the employee on notice or on summary. We'll explain what that means. So if an employee has been employed for 6 months or less, then they must serve a notice period of 1 week. If an employee has been employed for 6 to 12 months, the employee must serve a notice period of 2 weeks. And then if an employee has been employed for more than 12 months, then they must serve a notice period of 4 weeks. Or if an employee was a farm worker or a domestic worker who has been employed for more than 6 months, even if it's less than 12 months, then they must also serve a notice period of 4 weeks. So with regards to serving the notice period, the employer is entitled to an employee serving that notice period. So if an employee, for instance, wants to terminate their employment, wants to resign, then they must give the employer a notice in terms of whichever notice period is applicable. If, as we've mentioned, if depending on the length of your service to that particular employer. Then when an employer receives notice from an employee, the employer can decide whether or not to accept that notice period. If an employer, for instance, decides that, you know what, our relationship is so fragile or is so toxic that I just want to see you leaving and I don't want you to serve the notice period. So for instance, if an employee says, here's my notice, I am resigning, or my last day of employment would be on this particular date, and the employer is like, you know what, you can leave now. So basically what the employer would be doing there, the employer would be waiving the notice period. So in terms of section 38 of the Basic Conditions of Employment Act, if an employer waives the notice period, so tells he or she tells the employee to just leave without serving the notice, then the employer has to pay the employee for that particular notice period. So if the employee had to serve 4 weeks notice, then the employer would pay that employee remuneration equal to 4 weeks. If the employee was supposed to serve 2 weeks notice, then the employee must be paid 2 weeks wages. So the next point is that in terms of section 40 of the Basic Conditions of Employment Act, an employee must be paid for any paid time off that the employee is entitled to in terms of section 10.3 or section 16.3. So in terms of section 10.3, it's a section which regulates overtime payments, and section 16.3 regulates for payment for work which was done on Sundays. So if at the termination, so an employee resigns and they still have overtime payment that is due to them, or they still have payments which is due for work done on a Sunday, they must also receive, in addition to notice payment, they must also receive payment for overtime that is due or for work that was done on Sundays. And furthermore, an employee must be paid for any period of annual leave which was due when the employment is being terminated. So the third type of payment that is due is annual leave. If at the time that an employee is being dismissed or retrenched, or the employee resigns and they had annual leave days which were due to them, then they must be paid for those annual leave days that are due. So again, or more so, an employee who has been employed for longer than 4 months, this is still with regards to payment for annual leave. So an employee who has been employed for longer than 4 months, but the annual leave cycle was incomplete, the employee must be paid 1 day's remuneration for every 17 days work completed. So if, for instance, you've worked for 4 months, the annual leave cycle is still approaching midway, and you resign on the 5th month, for instance. So what has to happen is that the employer has to pay the employee one out of each 17 days completed work. So in terms of Section 41 of the Basic of Conditions of Employment Act, it further provides that an employer must pay an employee who is dismissed for reasons based on operational requirements, or whose contract is terminated because the employer had become insolvent, which is in terms of Section 10 of the Insolvency Act. So this is the section which deals with what most people would know as service payment. You know, people call it service payment, but in actual fact, it's severance pay. So if you go to Section 41 of BCEA, it provides that for every 1 year completed in the service of the employer, an employee is entitled to 1 week's wages for severance pay. So if someone has worked for an employer for 7 years, full 7 years, then they must receive seven weeks wages. If you've worked for 3.5 years, then you must receive 3 weeks of wages, because the year must have been completed. So if you worked for, let's say, 7 months, then you are not entitled to any severance pay. If you worked for 1 year, 7 months, then you are entitled to only 1 week wages. So in addition to paying the monies which are due to the employee, the employer must provide the employee with a certificate of service, and this is in terms of Section 42. You know, and there are instances in which an employer we've heard that an employer has refused to give an employee a certificate of service, but that is not lawful, and that is not fair as well, because Section 42 of the Basic Conditions of Employment Act provides that anyone is entitled to receive a certificate of service, and the certificate of service can include or should have details such as the full names of the employee, the full names of the employer, and the address of the employer. It must have the job description. It must also have the remuneration at the time of termination. And if the employee insists or asks the employer to include, the employer can include the reasons for termination of employment. So those are the monies in terms of legislation, in particular in terms of the Basic Conditions of Employment Act, that are due to an employee who is dismissed, who is retrenched, who has resigned. So now, in addition to all of that, one more aspect, or one more form of payment that can be received by an employee who has lost their job is UIF, Unemployment Insurance Fund, monies or compensation from Unemployment Insurance Fund. So these monies are received only when an employee is dismissed or has been retrenched. So when an employer dismisses an employee or retrenches them, they must provide them with a UI-19 form, which must be filled and then submitted to the Unemployment Insurance Fund for compensation for the period of unemployment. However, when you resign, you don't get to receive UIF, because unemployment came about at your own instance as an employee. And yeah, just as the last point is to say, if an employee was a member of a provident or a pension fund, then they can make applications to receive their monies which are due. That was the 3rd episode of our labor law series. Thank you for joining us, and please hit the subscription button and also the notification button so that you can receive our content as soon as we upload it. Remember, the law is for justice, the law is for reparation, and the law is for building. Thank you for watching.